The Minnesota Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Minnesota. What is a rental agreement? A rental agreement, or a lease, is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord should also disclose to the tenant the names and business addresses of the people who own and are authorized to manage the rental unit. Another thing the prospective tenant should know before entering into a lease is if the landlord has received notice of a contract for deed cancellation or notice of a mortgage foreclosure sale and the date on which the contract cancellation period or the mortgage's redemption period ends. One more disclosure the landlord is responsible for is providing an outstanding health and safety inspection order with a citation issued for it regarding the premises. The landlord must disclose it in the lease agreement before the tenant signs or pays a security deposit. However, if the pending order is not deemed a health risk, the landlord must instead include a notice that the inspection order is available for review upon request. The landlord may also import the late fee in the rental agreement if it is agreed with the tenant. Such a fee may not exceed 8% of the overdue rent payment. The last disclosure in Minnesota is a shared utility agreement. It includes an equitable method of apportionment and the frequency of billing that should be provided by the landlord in writing. Security deposits. According to the Minnesota general laws, the maximum security deposit is completely up to the landlord. The landlord should return the security deposit within 3 weeks after termination of the tenancy. Or, if the tenant vacates the building or dwelling due to the legal condemnation of the property, the deposit should be returned in 5 days. The landlord can use the deposit to pay unpaid rent or repair any property damages caused by the tenant after sending the tenant an itemized list of damages and their costs. If the landlord fails to return the security deposit, the Minnesota laws make the landlord liable for the full deposit with interest, as well as a penalty equal to the amount withheld, plus up to a $500 fee. Landlord access. The Minnesota laws require the landlord to enter the rented dwelling only for a reasonable business purpose such as inspections or necessary repairs, and after making a reasonable notice. Termination of agreement. In case of tenancy at will, which is a rental agreement without a set end date, a written notice should be sent at least as long as the interval between the time rent is due or 3 months, whichever is less. Notices for non-payment. If the tenant fails to pay rent, the landlord should send at least a 14-day written notice to either pay or quit.